Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas in this honorable court.
Please be seated. Good morning. Welcome to the Supreme Court of Texas. We'll hear four arguments this morning. The first is 230848, Third Coast Services and Spa Glass Civil Construction against Castaneda from Harris County and the 14th Court of Appeals. The second is Texas Commission on Environmental Quality against Paxton, case 230244 from Travis County and the 3rd Court of Appeals. The third is In Re UMTH, a mandamus petition from Dallas County and the 5th Court of Appeals, case number 240024. And finally, 240307, In Re HS, BS, and MS from Parker County and the 2nd Court of Appeals. The court has allotted 20 minutes to each side in each of the cases. We'll take a brief break between the arguments, which can be viewed online and will be available on the court's website later today. We'll hear 230848, Third Coast Services and Spa Glass Civil Construction versus Castaneda.
May it please the court. Mr. Goles and Ms. Barger will present argument for the petitioners. Petitioners have reserved 7 minutes for rebuttal. Mr. Goles will open with the first 13 minutes. Ms. Barger will present the rebuttal.
May it please the court. The plain language of section 97002 of the Civil Practice and Remedies Code does not require that there be a direct contract between TxDOT and the contractor invoking the statute. For that reason, we would ask that the court reverse the Court of Appeals judgment. Now, if we have time, I'd also like to address the contract compliance issues and ask the court to render judgment in favor of petitioners on that issue as well. But let's begin with the lead issue, the proper interpretation of section 97002. Now let's jump right into the heart of the matter. Why does the statute single out TxDOT? Why does it not use the general term governmental unit? And I'll tell you why, and it's actually a very simple, straightforward answer. The legislature intended to protect those contractors who construct or repair part of the state highway system. That those terms, a highway, road, or street for the Department of Transportation, all that means when analyzing the statute is part of the state highway system. And that interpretation is grounded in the Transportation Code. If you look at section, we've cited this in our briefing, 224.031 of the Transportation Code. It delineates the duties of the Texas Department of Transportation, and subsection A states that the department has exclusive and direct control of all improvement of the state highway system. So this is an easy, simple test to apply. If a contractor is required to improve, and what I mean by improve is construct or repair, any part of the state highway system, it qualifies for the statute's protection. That box is checked off, and you can look at the remainder of the statute to see whether its requirements are met.
Can a state highway system have a toll, a piece of the state highway system have a toll on it?
Yes, and actually part of this project, when I say project, I don't just mean the segment in Montgomery County. I mean the entire length of the project, the tollway, or I say tollway. The TxDOT contract with Montgomery County speaks to the SH249 project. SH, of course, refers to state highway.
Right,
Part
and
of
the
that is tolled
contract
by
says that it's not part of the state highway system.
The county segment.
Right.
The TxDOT segment is.
Right. No, I understand, but what I'm asking you is, did they do that because they wanted to put a toll on it? In other words, can it only be a toll road if it's not part of the state highway system?
I don't believe so, because the TxDOT segment controlled by TxDOT is a toll road, and it's part of the state highway system, and that's made evident by the TxDOT agreement with the county. So
there is a toll road on the portion that's outside of Harris County.
Yes,
there is a toll.
Yes, TxDOT itself constructed 2 segments of the tollway. This agreement refers to it collectively as the TxDOT project, one segment of the TxDOT project is tolled and the other segment is untolled. I believe it's the northernmost portion going into Grimes County that's untolled. Now let's dig a little deeper into our proposed interpretation as to what "for" might mean. And we have two interpretations that are not mutually exclusive. We've set forth both of them in our briefing. The initial meaning "for," you think of it as "for the benefit of." Was some construction or repair work performed for the benefit of TxDOT? And in our case, you can look to the specific construction work that forms the basis for the plaintiff's claims. And what I'm talking about are the traffic signals that were constructed on State Highway 249 and the intersection of Wood Trace Boulevard.
It's actually on the frontage road, right?
Yes, and let me be clear about that. I'm glad you said that, Your Honor. Frontage road, when we say frontage road, we're actually talking about State Highway 249. Before the commencement of this project, State Highway 249 were the frontage roads. It was 3 lanes going in each direction, north and south. Before the project, that was State Highway 249. During the project, it was State Highway 249, and still today you can drive out there and see the rectangular black and white State Highway 249 signs. So what we submit is that any construction or repair work performed as part of the project on the State Highway 249 frontage roads were necessarily for TxDOT. And why was it necessarily for TxDOT? It's because that's part of the state highway system. And the TxDOT contract with the county makes clear that TxDOT operates and maintains those, the State Highway 249 frontage roads. And if you have any lingering doubt as to whether those traffic signals were for TxDOT, you don't need to look any further than plaintiff's own summary judgment evidence. Look at their Exhibit 13. It's page 664 of the clerk's record. They feature this particular email in their summary judgment response. And what it states is that the TxDOT guy, Adam Galland, that I talked to about borrowing poles for this intersection work, stated that since these lights were going to be controlled by TxDOT after the project was complete, your electrical subcontractor needs their work to comply with TxDOT standards. That's as far as you need to look in this case. The construction of those traffic signals constitutes construction or repair of a highway, road, or street for TxDOT.
You offer a limiting principle to what you just explained. So traffic light might be sort of in the middle, but you could get, under your argument, I think, to a point where you say parking signage is part of the road, landscaping is part of the road, a bus stop is part of the road. I mean, are you arguing that there should be immunity for landscapers?
No, and fairly, could landscaping be considered maintenance versus construction? I mean, I think it might depend on the definition of highway that you adopt. In our case, both sides are advocating that the definition of highway from the Transportation Code ought to govern, which defines highway to include things such as a building or even a necessary structure related to a public road. And so we certainly submit, and I think hopefully the court would agree, that certainly traffic signals are structures necessary to the
I think
use of the
necessary
public road.
the word necessary is doing a lot of the work there, and so that
Sure.
is sort of a flexible term, right? What you might think is necessary, I might not agree is necessary. And so on a major thoroughfare like this, I think probably it's right that traffic signals are necessary, but they're not everywhere. And so how do we draw the line? But can you offer a limiting principle?
You know, I keep going back to the definition of highway as to what constitutes construction. If you're constructing part of a highway, if you're constructing something necessary to use the roads, then I think that, I mean, certainly, I guess you could make an attenuated argument that like landscaping, like maintaining the landscaping on either side of the road would be necessary for visibility, but that strikes me more as maintenance versus construction or repair, because you're not constructing anything when you're mowing the lawn, right? I mean, let's be clear
What about pursuant to TxDOT specifications? If something is pursuant to TxDOT specifications, is that a good way to decide whether it's for TxDOT?
I think that's probably fair, right? Because the TxDOT contract specifies that because the entire tollway, including the segment in the county, was constructed on state highway right-of-way, that the
Well, I'm talking
specifications
about like
had
the
to.
specifications for the traffic lights.
Oh, right. And fairly, Your Honor, I'm not certain if
Because
there are.
there's probably not specifications for landscaping.
That's what I was
that are-
just about to say. I'm not aware that there are. But let's be clear about the traffic signals too, Your Honor. I mean, imagine the work that is required to construct traffic signals, right? I mean, I'm not certain that this is specified in the record, the exact dimensions of the mast arms. When I say mast arms, I'm referring to the arms that extend out over the road. One was something to the, I think, 55 feet and 32 feet. Imagine the lateral weight of traffic signals. What I'm getting at is that they have to go 15 feet beneath the surface of the road to affix these things. The foundations are immense, and construction by any definition of the term would involve the work required to construct the foundations for these traffic signals. So certainly we submit that construction of traffic signals constitutes construction of a highway, road, or street for the Department of Transportation. Now the other definition.
Even if we agree with you that for TxDOT would include a contractor like your client, it's an affirmative defense, right?
That's right.
So on summary judgment, it's your burden to conclusively establish that all of your work was done in conformity with TxDOT specifications.
Yes, Your Honor.
Okay. And I imagine those specifications are this wide and this tall and, reams of paper. How does one conclusively establish that all of your work was done according to TxDOT specifications? And
that's
here,
sorry.
I think the argument is that you didn't adequately modify the traffic controls to allow for reasonably safe road user movement. I think that's what the other side relies on. So how do you point us to something in the summary judgment record that conclusively establishes that you complied with that requirement?
We've submitted 3 affidavits, or actually, I'm sorry, 2 affidavits and deposition testimony. But it's the testimony from the project engineer, and it's the testimony as well from Montgomery County's engineering representative, who both have testified affirmatively that there was compliance with the material contract documents at the time of the accident. So I think you would have to go about it that way. You would have to present evidence from the folks who, under the contract documents, have the authority to make that determination. You would have to present affirmative evidence, whether it be affidavits or deposition testimony, attesting that there's affirmative compliance with the contract documents. The provision that you just mentioned, Your Honor, we've argued that it's inapplicable here because of the use of the term modify. If you want me to address this, I'd be happy to. But our assertion is that the provision about modification of temporary traffic controls is not at play here, because what is the assertion is that we didn't add a traffic control device to the traffic control plan, not that we failed to modify whatever temporary traffic controls were there.
I thought your position was there weren't any temporary traffic controls.
Right, at the intersection, controlling the traffic at the intersection. What I mean by modifying the temporary traffic controls, what's in the summary judgment record, an example would be the U-turns for the State Highway 249 were closed off during the project. They were closed off using barrels and Type 3 barricades, and you can see those. I think you can see the barrels in the photo that we've appended to in our appendix. Those were temporary traffic controls, part of the TxDOT approved plan to block off the U-turns. During the course of the project, TxDOT directed Spallglass, the general contractor, to remove one of the Type 3 barricades to improve visibility, which shows not only TxDOT control, but that's the sort of action contemplated by that particular contract provision. That is a modification of the temporary traffic controls. What they want instead is us to add a traffic control device to the traffic control plan that was not called for in the plans. And that is very different than modifying whatever temporary traffic controls were out there. And this court knows very well from the Christ case what happens when a contractor modifies a traffic control plan. You can't do it without the requisite approval of whatever governmental entity is in control. Here it would be Montgomery County and TxDOT. And so, and again, that's established by the summary judgment record. All these changes had to be approved by TxDOT before anything could be done.
So what's to happen when a traffic control signal fails inspection and there's inadequate power to it, or the power hasn't, what's to happen then? Well, you're saying nothing should happen in connection with, long time.
Oh, you mean during the course of the project? If
Right,
the
during the
signals
course
weren't-
of the project, I think the suggestion is that the lights failed inspection, and that because of that, extra work had to be done, something had to be done. But you're saying that wouldn't be governed by this provision about reasonable road user safety, or reasonably safe road user movement.
Well, let's remember under these facts, though, that the traffic signals were not scheduled to be operational until February of 2020, and they were actually operational about 6 months ahead of schedule. But if hypothetically, let's say once the lights were turned on, let's say after this particular incident, if the lights were turned on and then there was a power outage, I'm not certain exactly how that would be handled. I mean, because, if it's a signalized intersection, it reverts to a four-way stop automatically. But I suppose what would happen is either you'd have somebody out there, I don't know if it would be flaggers or off-duty police officers or somebody directing traffic through the intersection until power were restored. I think some action would be taken like that. And I see that my time was up. If anyone has
Any further questions? Thank you, Mr. Goals.
Okay, thank you.
We'll hear from the respondent.
May it please the court, Ms. Gibson will present argument for the respondent.
May it please the court. The statute at issue in this case is specific and clear. Petitioner started with a rhetorical question as to why the statute in this case uses TxDOT and not governmental entity. And that's because there is a separate Texas Transportation Code statute that governs immunity or limited liability for contractors who have complied with the designs and specifications that are set forth by governmental entities. And it uses the language governmental entities. In this case, the legislature specifically chose to use the language TxDOT. They didn't use TxDOT specifications. They didn't use TxDOT design plans. They used the language for TxDOT. The statute cannot be segregated. The very first part of the statute refers to a contractor, one who contracts. The for TxDOT part of the statute modifies the contractor. And that interpretation is in line with the same interpretation of every court of appeals that has considered this statute until the Mahoney case. Even after the briefing in this case, the first court of appeals in the Weber versus Mubarak case that came out this summer acknowledged that it's well-established Texas law that this statute applies to a TxDOT contractor. It's undisputed. Third Coast Spa Glass were not TxDOT contractors.
Say you had a case where Spa Glass contracted directly with TxDOT, so they're a contractor, but Third Coast is contracting with Spa Glass. Would Third Coast be, would their work be for TxDOT in that circumstance?
In that circumstance, you're looking at a lineage of privity in which the Texas law has third-party beneficiary contract principles that would potentially provide that immunity down the vertical line of privity to Third Coast. We don't have that here. The contract between TxDOT and Montgomery County is distinguishable from the contract in the Mahoney case because this was not a project in which the tollway was going to return to the state highway system. This was a right-of-way that was conveyed to Montgomery County for Montgomery County to operate, maintain, but most importantly, to control the construction project.
So it was conveyed ahead of the project? Because my understanding was that TxDOT the state owned the frontage road while that construction was going on. Is that incorrect?
TxDOT owns the frontage road. They own the highway. A right-of-way was conveyed for the tollway, and in the contract it was built in that Montgomery County would control construction on the frontage roads.
Was the right-of-way planned to be conveyed, or was it conveyed ahead of the construction project or after the construction project?
The right-of-way was conveyed in the After the construction project, the right-of-way, the completion of the tollway and the operation of it as a toll road by Montgomery County would complete the conveyance of the right-of-way to Montgomery County. However, TxDOT ceded control, not only for the construction on the main lane tollway, but also the frontage road to Montgomery County. It specifically says in the contract between Montgomery County and TxDOT that TxDOT would be Montgomery County would be responsible for design and construction of frontage roads to accommodate the toll lanes. The only reason Spoglass and Third Coast were doing work on the frontage roads wasn't for the benefit of TxDOT, it was for the benefit of Montgomery County to allow access on and off of its tollway that it was going to operate under this contract. There are other provisions in the contract that do not appear in the Mahoney case. Mahoney turned on the fact that there was maybe primary responsibility for the project to the county in that case, but TxDOT took an overbearing oversight role in which you could argue again potentially that there was some sort of third-party beneficiary of TxDOT in that arrangement. In the arrangement,
If the county were conducting the project in a way that TxDOT didn't like, did TxDOT have the ability to step in and make sure that things were done the way it wanted?
TxDOT had the opportunity to request to inspect. There is on all highways some level of coordination with TxDOT. There's some level of specifications that are intrinsic in the way that we design highways in the state of Texas, but the statute doesn't say this applies to all state highways. It said contractors for TxDOT, contractors constructing for TxDOT. In this case, they were not constructing for TxDOT, they were constructing for Montgomery County in order to allow access to the tollway for Montgomery County.
Let's say the air conditioner is broken at the court, and so I call the Facilities Commission, and the Facilities Commission hires, Joe's air conditioner service to come, fix the court's air conditioner. They can't do anything to the building without asking me, but the contract is between the Facilities Commission and Joe, and I've got nothing to do with the contract. And then somebody says, Joe's fixing the air conditioner for the Supreme Court. That sounds like a correct statement to me, irrespective of the contractual particulars.
In that situation, it would be a correct statement. The court controls and has given agency to this other entity to act on its behalf. The contract between TxDOT and Montgomery County specifically disclaims, Clerk's Record 323 explicitly disclaims that this contract should not be deemed to create some type of principal agency relationship between TxDOT and Montgomery County. This court knows that a principal agency relationship turns on three things. First of all, the principal is giving permission for the agent to act on its behalf. Second, the agent is intending to act on behalf of the principal. And third, the principal controls. They specifically set forth in this agreement between TxDOT and Montgomery County that it should not be interpreted this way. Montgomery County was in charge of its portion of the project, its contractors, which Montgomery County funded, Montgomery County controlled, Montgomery County contracted for the work for the tollway project. The work on the frontage road in this case was also controlled by Montgomery County and was for the tollway that Montgomery County was going to operate. The statute does not use the language for the benefit of. The legislature knows how to do that. The statute does not use the language TxDOT specifications or all state highways, or TxDOT highways or highways owned by TxDOT. It doesn't use that language. It specifically uses contractor constructing for TxDOT. The 14th Court of Appeals, in the opinion in this case, interpreted that to mean it required privity. And they interpreted that because it makes sense when you read the statute as a whole. This court has said you can't read statutes in isolation. It contemplates that the immunity turns on contract compliance. Well, how is the judiciary to interpret which contract to look to for compliance? Even today, you've repeatedly asked petitioner about compliance with TxDOT specifications. Well, the contracts at issue in this case, the contract documents, they were issued by Montgomery County. Spoglass and Third Coast, they don't go to TxDOT for changes to the traffic control plan. They go to Montgomery County. TxDOT didn't issue the traffic control plan. Montgomery County issued the traffic control plan in this case. The agreements between Third Coast and or Spaltglass and TxDOT that are at issue, the contract compliance issues, are compliance issues that are in the contract between Montgomery County and Spaltglass. Specifically, the provision with regards to making changes to the temporary traffic controls to promote road user movement and public safety.
And that particular provision was not something that in any way was commanded by TxDOT?
That was not, it was part of the Montgomery County General Provisions Manual, and it was a term that was negotiated in the contract between Montgomery County and Spaltglass.
Having a very different provision would have been just fine with TxDOT, or is it something that would have led to problems with TxDOT?
TxDOT, as part of the coordination of the project, did review the plans that were put forth by Montgomery County, but they ceded control for them. The contract specifically says that TxDOT is responsible for, or sorry, excuse me, Montgomery County is responsible to the public for design of the signing and the lighting on the project. They also ceded it with regards to the frontage road specifically. Montgomery County is responsible for design and construction of any modifications to the frontage road that are being made to access the tollway, which is what was happening in this case. To
Justice Blacklock's, Chief Justice Blacklock's hypothetical, how is that different than, how is TxDOT ceding control to Montgomery County different than the court ceding control to the Facilities Commission to come and fix our air conditioner, which is not a hypothetical. Our air conditioner goes out all the time.
Presumably, there is some type of agency between the court and the facilities group. They're acting on behalf of the court.
So the difference is the disclaimer in the contract that Montgomery County is not to be considered an agent of
Not just that disclaimer, but throughout the contract where there's this division created between the TxDOT portion of the project, which was going to be managed and controlled by TxDOT, and the Montgomery portion of the project, which is expressly left to Montgomery County to be responsible for, to be responsible to the public for.
Was as everything, as a factual matter in terms of the allegations, everything, all the work geographically that led to this tragedy on the county portion, what's called the county portion, and not the TxDOT, the county project, and not the TxDOT project?
Yes, it is an undisputed fact in the record that was testified by the project manager for Spaltglass in the affidavit that they offered in support of their summary judgment that the traffic signals were on the Montgomery County portion of the project.
And so under your theory, is the location of the accident determinative about whether the statute applies?
In this particular case, because the contract specifically provided for Montgomery County controlling that portion of the project, and it's based off of a geographical location on the right-of-way of the state highway that was going to be ceded to Montgomery County, yes, in this particular case.
Right, but we have to think about other cases, and so I'm asking, do you think that a location-focused test is the right one for other cases?
I don't believe the test is location-focused. I think the test is based off of the relationship between the contractors and the entity for whom they're contracting, which is what the statute says. It says, are you working for TxDOT, contracting a contractor constructing for TxDOT? In this case, the answer is no. They were a contractor constructing.
Why isn't the answer, though, the statute uses the word for, though, it doesn't sort of incorporate an agency relationship, it doesn't refer to that expressly. It does use the word for expressly, and sort of along the lines of the air conditioner hypothetical, there have been many times when I have two daughters. One of them frequently takes on babysitting jobs that she doesn't end up performing because what she has is a younger sister who she can often say, hey, will you take this job? And when the younger sister takes the job and performs the babysitting work, I feel like she is performing it for the mom who hired her older sister, but also for her sister. So why can't for be for both of the entities, the county and the TxDOT?
Because this county tollway project was not for TxDOT. It was for the county. It was for the county who was going to benefit from the toll revenues. It was for the county that was going to operate and maintain this tollway as
But it could, right? I mean, you're not disagreeing that in some circumstances, the example Justice Huddle just gave, you can have multiple objects of four. You're just, I take it that you're saying only in this circumstance it's not, but that it could be, or are you saying, nope, it's got to be for TxDOT and TxDOT alone?
Well, the statute says for TxDOT and TxDOT alone. And
Well, it says for TxDOT, it doesn't say alone, and if it is for TxDOT, the fact that it is also for someone else doesn't stop it from being for TxDOT.
I think it turns on the fact that the requirements of the statute ask you to look to the contract, the formal document for compliance. And in this case, there is no contract between the contractors and TxDOT to comply with.
So in response to Justice Busby's hypothetical, where if we had taken Montgomery County out of this chain of contracts, you'd said that then a subcontractor like Third Coast could perhaps get the benefit of this immunity. So what would you be looking to in the contract between the contractor and the subcontractor to decide like what are the material terms, and then how do you make that third-party beneficiary relationship for TxDOT as between the subcontractor and TxDOT?
I think the contract principles of third-party beneficiary require there to be an intent for the subcontractor to be performing the services on behalf of the principal. In this case, it would have, if in your scenario, if TxDOT was the contractor or the party who contracted with the general contractor. And I think that type of vertical privity and analysis is throughout Texas law. The difference here is the control over the project. This isn't an instance in which the TxDOT went to Montgomery County and said, Montgomery County, please go out and hire these contractors to improve our roadway. No. Montgomery County negotiated.
It is that, though, isn't it? Because it was TxDOT's roadway. They're the owner. So it was go out and do all this to improve our roadway. And then at the end of the project, we'll give you a right-of-way? Is that how it worked?
That's not how it works in the contract.
Okay, how did it work?
How it worked was Montgomery County determined a need to have this tollway in their portion of the county, their portion of Texas. Okay. And that it would service the Montgomery County citizens and that it would improve the road user movement through Montgomery County. There was an ongoing assessment of creating a tollway that spanned multiple counties.
Right, but for this particular section, this highway was owned by TxDOT. The ground underneath is TxDOT land, right?
Yes.
Okay.
It is.
That was my point then, that they are in the chain in the sense that they are an owner of the land.
They are an owner of the land. However, they did not, almost like a lessee, that this was a conveyance of this property to somebody else to control and operate and maintain and to be the person responsible for to control and be responsible for that portion of the roadway. When you think about sort of general premises liability requirements, it's about control. It's who is the possessor, and in this case, the possessor was Montgomery County because TxDOT had ceded all of that control to Montgomery County.
Did TxDOT have any control over the selection of the contractor or of the terms of the contract?
No, TxDOT did not have control over the selection of the contractor. Specifically, the contract between TxDOT and Montgomery County put full control of awarding and funding construction contracts to Montgomery County. TxDOT, as part of the coordination process, did have the opportunity to review the contract documents, but it did not have the opportunity did not control the awarding or funding. It also didn't make the plans. The plans were developed by and designed by Montgomery County.
I thought there was evidence that TxDOT made the plans for the signals, a TxDOT engineer for the signals at this intersection.
There are TxDOT design specifications that go into traffic signals so that they're sort of uniform and meet minimum requirements across the state of Texas. But again, that's coordination. That's not, and that's not what the statute says. It doesn't say, do you meet TxDOT specifications? It asks, is the contractor constructing for TxDOT,
Aren't there
not
li-
is the contractor meeting TxDOT specifications.
Aren't there limitations on the ability of an agency like TxDOT to just give away state property to a local government? Did TxDOT get nothing in return? It seems like they got some sort of improvement with coordinated uniform lighting and things like that to improve traffic flows. So did TxDOT, was there nothing that happened for TxDOT's benefit in giving away this land?
Montgomery County, I believe, paid for the right-of-way.
Okay.
There's language in the contract that contemplates that Montgomery County would pay for the privilege of operating and running this right-of-way.
I want to be sure you have a chance to address Justice Bland's question about whether there's a fact issue on compliance or not. Can you talk about that?
Yeah, the record is wrought with instances in which there was non-compliance with the contract. In particular, we focused on there was Spaglass's repeated ignorance of concerns about this specific intersection, from the project engineer for Montgomery County to other contractors simply passing through this intersection. They were repeatedly told this intersection is dangerous. People treat this area as a racetrack, that there had been a potential fatality here. They were asked to expedite the traffic control signals, to look at the traffic control plan and do what was necessary to ensure public safety. They didn't do it. The record shows that they ignored these warnings after warnings after warnings, making no changes to the traffic control plan when their contract with Montgomery County required them to make modifications as accidents and incidents occurred. There are repeated accidents at this wreck happening in the exact same way as the wreck that killed Mr. Castaneda. What's even more telling is that they had the ability to get these lights on because they did it within weeks of Mr. Castaneda dying. And it wasn't TxDOT, it wasn't even Montgomery County that spurred the action to finally get the lights illuminated. It was the contractors. It was their negligence. It was Third Coast's failure to conduct that re-inspection timely. The contract between Spaglass and Third Coast required Third Coast to complete the work as it progressed, not wait to the very last day of when the contract was supposed to be finally due. That's not what the contract documents say for Third Coast. Additionally,
Thank you, counsel. Your time's expired. Are there any further questions? All right, thank you very much.
thank you.
Ms. Barger, I believe you have 7 minutes.
May it please the court. TxDOT had the right to review and approve the plans. TxDOT had the right to inspect the work for compliance and approve the plans. Montgomery County had to certify TxDOT had the project was in accordance with the plans and specs. The county project is not part of the state highway system only for so long as it's tolled by the county. There was a contention that this couldn't be.
Why is that? Can you not have the state road be tolled if it's part of the state highway system?
You could. So, I mean, here, this project right here, there was a joint project between the contracts. So the county and TxDOT, clearly, it was for both. If you look at the contract for the county project and the responsibility of the county project, and you go to paragraph B specifically states that the plans should be coordinated with TxDOT at all stages and shall be submitted to TxDOT for review and approval for the construction contracts.
But it also says the county shall have all responsibility to the public for the design, maintenance, and signing and lighting on the county project.
Right here it says, but when we go back to the paragraph B, TxDOT shall be responsible for the operation and maintenance of the frontage roads that are adjacent to the county project. Here, where this, and they were installing the lights, that was the Wood Trace intersection. The Wood Trace intersection was always, and it always has been, part of the TxDOT, or the Texas State Highway system.
Is it your position that eventually this section would become part of the tollway, and at that point, TxDOT was ceding operational control? It sounds like the contract documents may be less clear about that. When did TxDOT eventually cede control when it's operated as a tollway?
So at the
ahead of construction or after construction?
It would be after construction, Your Honor. I mean, I think that TxDOT would be responsible for all operations and maintenance of the project. And there was coordination between TxDOT and the county for the entire project as it was going on. And that is why that there was a whole, it's almost like the Mahoney case. The Mahoney case is very similar. In fact, when the first court held this, the petitioners were performing work clearly for TxDOT, and Spyglass's contract came about because of the county's partnership with TxDOT for the 249 project. So there is really no fundamental difference here. We all know that TxDOT will partner with cities and counties for these projects, but still, in this project was specifically regulated as a TxDOT project, and it was to be TxDOT designated a portion of the state highway as a future toll facility. The wood trace
Did TxDOT have any control over who the contractor was, who the county chose?
So under section 4C of the contract, it does say that TxDOT during any time such construction and providing reasonable notice to the county can inspect the work and in compliance with the engineering and design and specifications. So I do think that TxDOT did have some control. There was
Isn't that the case for even the most routine projects that have nothing to do with roads? If you want to build a room on your house, you're going to have dozens of city inspectors come in. You're going to need approval and permits and all this kind of stuff just to be able to do something like that. But we wouldn't say that that was done for the city, surely, would we? Building the extra room over the garage, let's say.
I think when you're looking at the statute and you're looking at the word for, when a contractor is doing construction work for TxDOT or either a highway, street, or road, I think you have to look at going back to the limiting principles. What does that mean?
I guess what I'm getting at is you've referred several times to the ability of TxDOT to inspect, to things to be done in compliance with their standards. That just seems routine. That doesn't sound particularly unusual. And so there must be something else, and that perhaps is ownership or some kind of control. Like the Chief Justice's question was, did they have ability over the contractors? But the ability to inspect doesn't seem like that. That's, governments do that all the time for new developments within our state. So what is it beyond that kind of normal governmental oversight of major projects that could affect public safety, let's say, that would make it for TxDOT?
So I think what makes it for TxDOT essentially is when TxDOT is regulating it. When TxDOT has the oversight. Here in this situation, TxDOT and the county, they have a contract, and they had a contract for the county project, but it was all with the TxDOT specs and the TxDOT standards. So that was required by, when we go back to all of the contracts, whether it was Spyglass's contract or whether it was Third Coast contract, they had to follow and incorporate all of those Texas specs and standards. So I think if then I think you're looking at for TxDOT. I mean, I think that if you're...
So any project that's governed by TxDOT regulations, TxDOT in the role of regulator is sufficient to trigger this provision that the work is being done for TxDOT, even if, for example, there's no dispute about ownership, and ownership is owned, the road is owned by the city or the county, not TxDOT.
I think in this situation, I think you need to look at, is TxDOT in the contractual chain somewhere? And here they are. They are clearly in the chain. They contracted with the county, just as in the Mahoney case when there was a contract. Or you can look at, is TxDOT the recipient of the work? Do they benefit from the work? This contract specifically states, right at the beginning of the contract, that TxDOT will have substantial benefits from this contract. And if you look at paragraph 15, this agreement is entered for the sole benefit of TxDOT and the county. So I think if TxDOT is the recipient, or if TxDOT has the right to inspect or approve, or you're using TxDOT specifications or standards, or it's construction on a state highway system. I think there has to at least be some overlay of TxDOT for the statute to apply for a contractor working with TxDOT. I think a different scenario would be 2 cases out of this court, Brown and Gay.
Counsel, I'll stop you there. Your time has expired. Any further questions? Thank you, Ms. Barger. Thank you to all counsel. The case is submitted and the court will take a brief recess.
Rise.